Hello, everyone. I'm going to go ahead and jump right in. It's 7 o'clock-ish. Let me share my screen. So tonight I am going to go and I'm going to go through and I'm going to finish the this versus that, which is at the end of your packet. I think it should be page like 36 or something like that is where we ended. So on Monday night, I ended with judicial activism and restraint. So tonight we'll pick up on original intent versus living constitution. I'm going to go ahead and jump right in. So with these two, this is in regards to like judges, federal judges, and how they make decisions. So original intent is judiciary should interpret the Constitution, including its amendments, in accordance with the understanding of its framers. So if a judge interprets the Constitution with its original intent, okay, that will be we will call them like an originalist, and they are literally interpreting the Constitution as the framers intended it, or at least that is how they try to interpret the Constitution. They try to understand how the framers intended the Constitution to be. So usually judges who are original or use originalism are pretty conservative. Yeah, I think that's good for that one. So then on the other side, it's living constitution. The United States Constitution holds a dynamic meaning that evolves and adapts to new circumstances, even if the document is not formally amended. So what this means is judges in today's time aren't necessarily looking at the Constitution and going, okay, we have to interpret it exactly how the framers intended it to be, like an originalist would, but they're kind of changing time periods and taking that into consideration before they're making a decision on any given case that's brought before them. So there's a difference in the two. And I would say that more liberal judges probably use this kind of concept more than conservative judges would. And the next is district courts versus Supreme Court. This is super easy. So we know the district courts are that lowest level of the federal judiciary. At the district level, they're the only level that's actually going to hear a full trial. So, you know, there's one judge, there's a jury usually, there's going to be, you know, a plaintiff and a defendant in most cases. There's going to be evidence and testimony and witnesses and stuff like that. And then there's going to be a decision made by a jury. And that, again, at the district level, that bottom level, that's the only time we see something like that. As you make your way up in the federal court system, the appeals in the Supreme Court are not necessarily hearing a full trial. They're just reviewing the cases that came to them and making sure that there were no mistakes made and that the law was applied fairly in those cases. The district courts have original jurisdiction. So remember, that's the authority to hear a case first. And there's hundreds of justices at the district level across the country, and 94 total district courts. There's at least one in every state. There's actually 2 in Missouri, and then there's like, you know, there's a couple for the territories. I think there's one separate one for DC. So that's where we add in those, that 94. And then on the Supreme Court side here, we know that's the highest court in the land is the Supreme Court. And again, they do not hear a full trial. What they do is just review cases that come to them from the lower levels to ensure no mistakes were made and that the law was applied fairly. They do have original jurisdiction, but they also have appellate jurisdiction. So they can hear a case for the first time or on appeal. It just depends on what the case is covering. There are 9 total Supreme Court justices, and the 1 Supreme Court is in Washington, D.C. Original versus appellate jurisdiction, then I literally just covered these. So original jurisdiction is the authority of a court to hear a case for the first time. And again, at the federal level, this is going to be the district courts and the Supreme Court. And then appellate jurisdiction is the authority to hear a case on appeal. So again, at the federal level, it's going to be the circuit courts and or sometimes we call those the appeals court or the appellate courts, and the Supreme Court. Okay. Moving on to national government versus states' rights. So if we're talking about the national government, we know that the Constitution gives certain powers, certain specific powers to the federal government, and the states cannot necessarily infringe upon those rights. So these are going to be things like declare war or coin money, things that definitely the states are not taking care of at all. The state of Missouri is not going to declare war on the country of Germany, right? The state of Missouri is not going to coin their own money. They're not going to print their own money. It's coming from the federal government. On the other side of that then is states' rights, and this is referring to political rights and powers that are granted to the states by the Constitution, and it's not necessarily specifically stated in the Constitution that the states have these rights. But what we do know is that the 10th Amendment gives reserved powers to the states. So it says in the Constitution, anything not delegated to the federal government or denied to the states remains with the states and the people. So we assume then that the states take care of things because it's not mentioned in the Constitution. They take care of public education, things like driver's licensing and professional licensing. So like Mr. Shaw and I, our teaching certificates, our professional license come from the state of Missouri, not the federal government. Other things are going to be like things like elections, right? They're not mentioned in the Constitution, so the states handle things like that. Okay, then we get to, this is in regards to physical federalism. So we have dual or cooperative. And in my class, I'm not sure about if Mr. Shaw does this, but in my class, we compare dual federalism to like a layered cake. So if you can imagine a layered cake, it has very distinct layers with like icing in between. Those layers do not overlap or mix in with each other. And so we can kind of imagine dual federalism in the same way. You have the national government that has very specified powers that are granted to them. You have the state governments that have very specified powers that are granted to them. And those things are both sovereign in their own respect, and they do not overlap. On the other side of that, then we have cooperative federalism, which we would compare to like marble cake, where the chocolate and the vanilla are kind of mixed in together. So in this regard, really there's no such separate spheres like it would be on the layer cake. Everything kind of is combined together. Both governments work together in tandem to formulate policy. And in regards to fiscal federalism, in this example, we can kind of compare it with the United States, where the federal government provides funding to the states in certain areas. Even in education, we know education is left to the states, but the federal government still provides federal funding for education to the states. It's not the entire, it's not Fort Zumwalt's entire budget doesn't come from the federal government. Some of it does, but that's kind of where we have that mixing of powers. Okay. Block grants versus categorical grants then. So block grants is going to be grant money from the federal government, which local authorities can allocate as they see necessary. So this is going to be grant money coming from Congress, the federal government, given to states, and the states are going to be able to kind of decide where that money should be spent. It doesn't really have a lot of caveat, or it doesn't have really a lot of implications. It's the states, here's money, allocate it as you will. On the other side of that, then we have categorical grants, which again are issued by Congress, the federal government, but they're going to put kind of like specific restrictions on that money. So they're going to say, this needs to be specifically used for education. This needs to be specifically used for transportation, or whatever it might be. But there's definitely a difference between the two here. Block is more broad. Categorical is going to be more specified. Okay. All right, these are two clauses that we find in the Constitution: full faith and credit, and then privileges and immunities. So full faith and credit clause essentially just says that each state must honor the laws, records, and court decisions of every other state. So it's like with driver's license. I have a Missouri driver's license, but that doesn't mean that if I go into Illinois, I can't drive, or it's illegal for me to drive in Illinois. The state of Illinois honors my license as Missouri has issued it to me. Therefore, it's legal for me to drive in Illinois as well as Missouri. Okay, on the other side, then we have privileges and immunities clause, and it basically just says that no state may discriminate against a person who lives in another state. All have the same rights and pay the same taxes. So, you know, laws that apply to one state, essentially, in regards to citizens and individual rights, essentially those same things will apply to every other state. Now that gets a little bit fishy, you know, when it comes to like different, you know, like marijuana laws and stuff like that. But in general, no state's going to be able to discriminate against someone if a state allows something in their state that's not illegal in another state, then it should translate. Okay. Okay, next to our writ of certiorari, or certiorari, or writ of cert is what they abbreviate it to or shorten it to, and then writ of habeas corpus is the other one. So a writ of cert is, it literally translates to be more fully informed. So this is basically when the Supreme Court orders a lower court to deliver its record of a case so that the higher court, the Supreme Court, can review it. So this is going to be, you know, maybe the Supreme Court is not fully ready to hear a case, but they do want to see the court records of a case that has been brought to them. And so they're going to issue a writ of cert. So they're going to say, hey, we want to see these records so we can look through the details of this case before we make any big decisions on it. On the other side, then, we have a writ of habeas corpus, and this translates to, and remember, both of these are Latin terms. This translates to you shall have the body. So this is used to bring a prisoner or maybe another detainee before the court to determine if the person's imprisonment or detention is lawful. So an example of this is if you file a petition with the court because you want to be brought before a judge where reasons for your arrest and detention must be shown. So if you are put into custody for whatever reason by authorities, you legally have the right through a writ of habeas corpus, usually a lawyer would issue one, to be brought before a judge, and that judge is going to explain to you why you are detained or why you are in custody, or, you know, what laws they think you have broken. You can't just be put into jail for no reason. There has to be a reason, and that's, you know, that's what it means. You shall have the body. You have to be brought before a judge. Okay, civil liberties versus civil rights. So in my classes, I usually try to explain that although they're called the Bill of Rights, it would be better served if we called them the Bill of Liberties, because that's what they are. That's what liberties are. Freedoms guaranteed to us by the Constitution to protect us from the government. So this is things like freedom of speech, freedom of religion, right? Those can't necessarily be infringed upon because they are in the Constitution, in the Bill of Rights, and they're protected. Remember, again, civil liberties, the Bill of Rights would make more sense if it was called the Bill of Liberties. Moving then over to the rights. Civil rights are the legal rights that protect individuals from discrimination. So these are things that the government does and puts in place to protect people from wrongdoing. And so, you know, there are laws in place to prevent from employment discrimination. You know, think Civil Rights Act of 1964. I mean, that would connect perfectly with that. Okay. Equal Protections Clause versus Due Process Clause. So this is a little tricky because the Equal Protections Clause is in the 14th Amendment, and there is a due process clause in the 14th Amendment, but there's also one found in the 5th. So the Equal Protections Clause prevents state governments from enacting criminal laws that arbitrarily discriminate. So this was what was cited in Brown v. Board. Okay, so when they bring the lawsuit against the Board of Education of Topeka, Kansas, they are citing the 14th Amendment's Equal Protection Clause. They said, you know, these students, specifically Linda Brown, her equal protections are being violated by forcing her to go to a all-black school, which essentially is not as quality as the all-white school. So she's not being equally protected under the law. Okay. A lot of cases will cite the Equal Protections Clause. The Due Process Clause then prohibits arbitrary deprivation of life, liberty, and property by the federal government, except as authorized by law. So, essentially, the Due Process Clause protects us from authorities, law enforcement or otherwise, denying us or depriving us of life, liberty, or property without having gone through the due process steps. So, I'm read my Miranda rights, and then, I'm offered a lawyer when I'm being questioned, and I'm only held for a certain amount of time before they either charge me or release me. So those are all those steps law enforcement has to go through. And the Due Process Clause protects that. Okay. Establishment Clause versus free exercise. So we hit these really hard when we go through Unit 3, and there are court cases that would connect directly with each of these. So the First Amendment, these are both found in the First Amendment under freedom of religion. And the Establishment Clause forbids the government from establishing an official religion, but it also prohibits the government from taking actions that unduly favor one religion over another. Our example for the court case here would be Engel v. Vitale. Remember, it's essentially the Supreme Court decides that the violation of students' rights to have to sit through a prayer every day at school that's being recited in their classrooms. And it's not necessarily because the prayer was geared toward a specific religion. It was because these students were exposed to religion in general, and that would be a violation of the Establishment Clause in the First Amendment. On the other side, then we have Free Exercise Clause, and this, again, First Amendment, freedom of religion, protects citizens' rights to practice their religion as they please, so long as the practice does not run afoul of public morals or a compelling governmental interest. So as long as something is not illegal, essentially you are lawfully allowed to do this. You can't break the law and then arbitrarily claim it to be part of your religious practice. In that kind of a case, you would have to prove that you had been, it was a long-standing religious practice before that moment when you were caught doing whatever it was that was illegal. So the court case that we learn about in this is Wisconsin v. Yoder. And remember, it's Amish students who were pulled out of school after 8th grade, after completing 8th grade. And the state of Wisconsin essentially sued those parents and said, no, your kids have to be in school until they're 16 or 17. That's what the law says. We have reasonable responsibility to educate society, and we've made a law that everyone has to be in school until they're 16. However, the Supreme Court sides with the Amish families in this instance with Yoder. And the Supreme Court says that yes, we do have interest in educating society. However, in this particular case, it's not going to be super harmful for these kids to miss high school, right? They're not going to get that much more knowledge, by going through high school compared to what they would have if they stopped after 8th grade. And they will be in kind of a secluded society. So, whatever they're learning after 8th grade, when they're at home, on the farm or whatever it might be, they are learning things that will help their own society. And so it would be in their best interest to allow them to leave school after completing 8th grade because of their protections in the Free Exercise Clause. Okay. Separation of powers versus checks and balances. Kids usually kind of get these intertwined and kind of mixed up. So when it comes to separation of powers, it just means that we have 3 separate branches of government, and each of them have their own functions and their own specific powers. So, for example, the legislative branch makes laws, the executive branch enforces those laws or implements those laws, and then the judicial branch can interpret those laws. They each independently operate from each other. They don't necessarily need each other. But when we move over to checks and balances, then is where we see the checking up of the power, checking on the power of each each of the branches. So to maintain equal power among the branches, the framers put in place these checks and balances in the Constitution to ensure not one branch is becoming more powerful than the other. So it's going to be things like vetoing legislation. The president will do that, right? So the piece of legislation is coming from the legislative branch, and then the executive branch can veto that. That's a check, okay? The Senate is tasked with confirming presidential appointments. So the legislative branch says yes or no to the executive branch's appointments. That's a check, okay? The Supreme Court using judicial review, saying this piece of legislation or this act of the president is unconstitutional. Again, that is a check, okay? Guys, checks and balances are great to use or refer to in your FRQs. They're always very easy things to kind of put in there, here and there, to give you examples of something to kind of solidify the points that you're trying to make. All right, nomination versus confirmation. This is easy. So the president nominates a variety of positions within the government. Supreme Court justices, cabinet members, ambassadors, even things like the head of the CIA or a lot of the head of the White House staff positions, he appoints them. They don't necessarily have to be confirmed, not all of them, but most of them do. On the other side, then confirmation is just that the Senate confirms presidential appointments, and that is given directly to them. It's a power given to them by the Constitution. And confirmations, presidential confirmations, require just a simple majority. So if it's, any given cabinet member, as long as they get 51 votes from the Senate, they would be confirmed. Okay, then we move to impeachment versus conviction or removal. So just because a president is impeached, and we know this is something very relevant that has happened twice in the last couple of years. So as long as if a president is impeached, it doesn't mean they are removed from their position, okay? So impeachment is a two-step process. The House of Representatives will start the process, and they are the ones who will vote on what we call articles of impeachment, okay? So the House will say, here's the one or two wrongdoings that we think the president did. Let's vote. Let's have the whole chamber vote. If a majority votes yes, then a president is technically impeached. But that just means that the trial moves to the Senate, okay? For an actual trial, and the Senate serves as the jury. So the Senate will then usually conduct a whole trial, okay? And usually what happens is the Chief Justice of the Supreme Court will preside over that trial. And there's witnesses usually, there's testimony, there's hearings, all that kind of stuff. And then at the end of the trial, it's the Senate who will vote to convict or acquit. And a conviction requires a 2/3 vote. This has never happened before in the United States history. We've impeached several presidents now, but we've never actually removed them. And conviction requires a 2/3 vote, which is a pretty hefty task to do, especially in today's world. So yeah, moving on. Okay, moving to the amendment process then. Well, that's a lie. Let me go back. First, we talk about formal versus informal amendments. So formal amendments are actual changes to the Constitution, and there's a two-step process here: proposal and approval. Okay, so 2 ways to propose and 2 ways to ratify or approve. Most of the time, all but one time, okay, the proposal has been done through Congress. So both houses of Congress have to approve the proposal with a 2/3 vote. Then it goes to the ratification step. And this is where state legislatures will then vote to ratify. And 3/4 of the states have to agree. So it's something like 38 states out of 50 have to say, yes, we approve this amendment to be incorporated into the Constitution. And that's how it's been done every single time, except for once for the 21st Amendment, which repeals prohibition. And the ratification process was done through special state conventions, which isn't super important for you to know. Okay, the other side then is informal amendment. And this is just kind of like the idea that, we have policy changes all the time in government. And it's not necessarily changes to the Constitution, but it is, a change in how maybe we interpret the Constitution. So, we create laws, like the Civil Rights Act would be a good example, right? So, with changes in society, we make laws that reflect those changes as we progress. So this can be done through judicial review. So if we use the example of Brown versus the board, right? Basically, the court just uses judicial review to make these kind of progressive changes that affect the entire country, but not necessarily changing the Constitution. Okay, the next one is proposal versus ratification, and I think I've pretty much already covered this. I wanted to put this chart in here one more time for you to kind of see it bigger. But again, the proposal step is there's two options. Okay, we've only ever used the top. And then the ratification step is also two options, and all but one time we've used the top one as well. All right, necessary and proper versus commerce clause. So again, clauses found in the Constitution. Okay, necessary and proper. We also call this the elastic clause because it allows Congress to kind of expand its powers to fulfill its duties. Okay, so they can kind of pass laws that allow them to fulfill the duties that have been given to them in the Constitution. And what the necessary and proper clause says is that it gives Congress power to make all laws which shall be necessary and proper for carrying into execution other federal powers. So anything Congress really needs, usually they can make laws that will allow them to carry out their duties. And then on the Commerce Clause side, then the Commerce Clause authorizes Congress to regulate commerce with foreign nations, among the several states, and within Indian tribes, and it serves as the legal foundation of much of the government's regulatory power. So Congress uses the Commerce Clause with a ton of stuff. Okay, so they say, under the Commerce Clause, we have the power to do X, Y, and Z, regulate multiple different things. So the Commerce Clause really allows Congress to expand its powers, and so does the necessary and proper clause. And it is important to note that the Commerce Clause was one of those things that was added into the Constitution that they did not have anything like this in the Articles. And this was one of the kind of the big reasons why the Articles failed, is because Congress had no way to regulate commerce between the states. So New York was doing business with South Carolina, but each of them had their own importing and exporting taxes and laws, and they had their own form of currency, and Congress couldn't really touch any of that. They had no way to regulate any of that. So putting the Commerce Clause in allows Congress to really kind of oversee all of that economic activity, and a lot of stuff falls under economic activity. Okay. All right, delegated versus reserved powers. So delegated powers, also known as enumerated powers, these are what are specifically granted to the federal government. And these are going to be things like coining money, regulate commerce, declare war, raise and maintain armed forces, establish a postal service, issue copyrights and patents. These are all things that Congress can do directly given to them in the Constitution. Reserved powers, on the other hand, is what states have the power to do. And we find this in the 10th Amendment, right? The 10th Amendment says that basically it says anything not given to the federal government remains with the states. So again, I touched on this earlier, but it's going to be things like issuing driver's licenses, marriage licensing, public education, elections. All of those things are left to the states because they're not mentioned or given directly to Congress in the Constitution. Okay. Enumerated versus inherent powers. So again, enumerated powers, just like delegated powers, they're specifically delegated in the Constitution. So again, this can be something like declare war. Congress has the power to declare war. Inherent powers, on the other hand, are powers that Congress and the president need in order to get the job done right, but not necessarily given to them through the Constitution. They are reasonable powers that are a logical part of the powers delegated to the Congress and the president. So, you know, this could, you know, a lot of different things can fall under the inherent category. But as you guys know, we've learned this throughout the year. Since the Constitution was created, the powers of Congress and the president have expanded dramatically, and that's kind of where the inherent powers would fall. We assume that they have some of these, you know, powers that they can do X, Y, and Z to carry out the duties of the office that they're holding, but not necessarily granted to them in the Constitution. Okay, kind of on the same lines with this formal versus informal powers. This is in regards to the president. So formal powers are delegated to the president in Article 2 of the Constitution. And again, these are going to be things like vetoing legislation, grant pardons. It says that he's the commander in chief, so he can command the armed forces. Informal powers are those things that the presidency's kind of picked up along the way. So they're not listed in the Constitution, but they're tools that he needs to carry out the duties of the job. So we have come to just agree that informal powers would include executive agreements. Okay, so when he, you know, enters into kind of a deal or negotiation with a foreign leader, not necessarily a treaty though. Executive orders, which have the force of law but don't go through the lawmaking process, and then he can issue things like signing statements, which, you know, he'll use when he signs a bill into law. A president might write, you know, do a signing statement that, you know, it's his interpretation of the law or how he sees it being implemented. Okay, executive agreement versus executive order then, very easy. Executive agreements are negotiations or agreements that the president makes with foreign leaders. This does not require Senate approval. So the big thing here is that executive agreements, they're not going to be permanent. Usually they're temporary. You know, it depends on what it is, but sometimes executive agreements will end with a presidency. Sometimes if a new president takes over, they will end an executive agreement that a previous president had made. Executive orders are kind of in the same boat. So it's issued by the president, it has the force of law, but it doesn't go through the lawmaking process. And same thing with executive orders, they're not necessarily permanent, right? So they can easily be rescinded by the next president that takes over or that's elected to office. And it is important to know that executive orders are subject to judicial review. So if a president issues an executive order and somebody files a lawsuit claiming that it's a violation of rights or something like that, the courts can look at that executive order and use judicial review on it if it's brought to them in a case. Okay. OMB versus CBO. Okay, so Office of Management and Budget is under the executive branch. Okay, the Congressional Budget Office is under the legislative branch. So OMB, or Office of Management and Budget, serves the president, and this is the group, this is an entity that he works very closely with to create the budget. Okay. And it says they oversee the implementation of the president's vision across the executive branch. They oversee the performance of the federal agencies and administer the federal budget. So just as I just said, and then the Congressional Budget Office, they're a nonpartisan group. So they do not affiliate with a political party, which is not necessarily the case with the OMB, since some of them are appointed by the president. So they're going to align with whatever political party he or she is involved with. But the CBO provides objective, nonpartisan information that supports the budget process, because we know that the president creates the budget, right? But it's Congress who really has the power of the purse. So they can adjust the president's budget as they see fit. And their mission is to help Congress make effective budget and economic policies. So again, they are nonpartisan. Okay. All right, White House staff versus executive offices of the president. Okay, so these are both groups that work, again, closely with and under the president. The White House staff report directly to the president. This would include like his West Wing staff. Almost all of the White House office staff are political appointees, so they are appointed by the president. They do not require Senate confirmation though, and they can be dismissed very easily by the president because of that. So these are going to be people who are very close advisors to the president and that he relies on heavily. On the other side, then, the executive office of the president perform the presidential administrative work. They offer counsel in specific areas. Again, they're going to be advisors. They work to manage the economy, protect national security. These are going to this is going to include White House Office, National Security Council, Council of Economic Advisors, Office of Management and Budget. So these are going to be, I would say, almost like more formal positions under the executive office of the president in comparison with the White House staff. Okay, skip this. Skip Congressional Caucus and Nominating Caucus. I don't think you need to know that. And we're going to talk about caucuses in the next one. Okay, so Congressional Caucus is basically it's informal meetings or informal groups, organization of members of the House or the Senate or both that exist to discuss issues of mutual concern and possibly to form legislative research and policy planning for its members. So there is a Congressional Black Caucus. There's a Congressional Women's Caucus. There's a Congressional Conservative Caucus and Liberal Caucus. And so there are caucuses. There's a variety of different caucuses. And these are informal organizations. So these are not like committees where they're appointed to these different groups. These are, members of Congress in either the House or the Senate or both. Sometimes they are combined. There's a Senate, women's caucus of the Senate, right? So there's a women's caucus of the House. And they will meet pretty regularly to discuss common concerns, and try to come up with solutions to those, or maybe they meet